There's another meeting starting at 7 p.m. As we call this meeting to order, we'd just like to recognize that we conduct our business on the traditional territories of the Coast and Strait Salish peoples, and specifically recognize the Lekwungen people known today as the Songhees and Esquimalt or Kasapsum nations, and just that their connections to these lands and waters continue to this day. First order of business is approval of the agenda. Can I have a mover and seconder? Moved, seconded. All those in favor? Any opposed? None opposed. I do not have any remarks for this meeting. I do have some remarks in the 7 p.m. meeting. We have one meeting matter here. Of course, this is not subject to public input. It is the hearing for appeal of Section 2, Subsection 4 of the Public Sewer Bylaw, 1996 to 3383, related to, 3383 Henderson Road. I have some opening remarks. Just this is something we don't often do, and good to just have some clarity of process. This meeting is being held today to consider a decision that will affect Thomas Irwin. Mr. Irwin has requested that Council reconsider the decision made by the Director of Engineering and Public Works to require Mr. Irwin to pay the district's costs incurred as a result of installing a connection from Mr. Irwin's property to the public sewer pursuant to Section 2, Subsection 4 of the district's public sewer bylaw. Council has been provided the submissions from both the Director of Engineering and Public Works, and Mr. Irwin's legal counsel for today's meeting. The issue being considered today is whether the district was entitled under Section 2.4 of the Public Sewer Bylaw to require Mr. Irwin to apply for a connection to the public sewer and to pay for the required fee within 60 days, failing which the district could fulfill the requirement at Mr. Irwin's expense. Both parties were advised of the date, time, and location of this meeting and confirmed their availability. A copy of the staff report was provided to Mr. Irwin's legal counsel on August 13th, 2025. A copy of Mr. Irwin's submissions was provided to the district on September 25th. Council will first hear from the Director of Engineering and Public Works, who will provide a presentation identifying the reasons for the decision to require Mr. Irwin to pay for the connection and for the district to fulfill the requirement at Mr. Irwin's expense. At any time during this presentation, Council may ask a question for clarification, although comments and debate should not occur. After the Director's presentation, Mr. Irwin or his representative may ask questions of the Director and the presentation. Then Mr. Irwin or his representative will be provided the opportunity to present their arguments. Again, at any time during this presentation, Council may ask a question for clarification, but comments and debate should not occur. Following Mr. Irwin or his representative's presentation, the Director may ask questions of the presentation. Both the Director of Engineering and Public Works and Mr. Irwin's representative are reminded that the purpose of this hearing is to reconsider the Director of Engineering and Public Works decision under Section 2.4 of the Public Sewer Bylaw, which was to impose the cost of connecting to the public sewer on Mr. Irwin. It is not intended to debate the legality of the bylaw itself. Following the presentation, Council may seek legal advice during its deliberations and before it prepares its reasons. If this is the case, Council will put forward a motion to close the meeting pursuant to Section 9, Subsection 1I, to meet in camera for legal advice under the Community Charter. Council will then return to the open meeting to deliberate and decide on the information presented by both parties. I will note it is at Council's discretion whether the deliberations take place with both parties present or not. If Council elects to do so, they can notify the parties of their decision in writing. In closing, I would ask that all questions, presentations, and discussions be directed through the chair, myself. Director Rennick, the floor is yours. Please step up to the microphone and begin. And for the next presenter as well, just you can follow his process. Sit at the chair, push the button for the microphone to go on. That allows it to be seen online as well. Just state your name and before you start, go ahead, Mr. Rennick.
Thank you. Stephen Rennick, Director of Engineering and Public Works, District of Oak Bay.
Welcome.
Good evening, Mayor and Council, and thank you for the introduction, Mr. Mayor. I am here tonight to speak to the steps taken by the district in respect of 3383 Henderson Road. As noted in the district's submission to Council, this address was subject to bylaw enforcement for work without permit. In resolving the bylaw matter, it was determined that the property did not have a functioning storm sewer connection, and they were directed to apply for a permit to have this connection resolved. This is consistent with the approach that the district has taken for other properties that are not properly connected to the district's sewers. Oak Bay's bylaws place the financial responsibility for making and maintaining a connection to the public sewer onto the property owner who is served by such a connection. And this is similar to other jurisdictions in British Columbia, for instance, City of Abbotsford. In this case, the property owner contested the district's authority to require a sewer connection. The bylaw allows the district to order an owner to apply for a sewer connection and to take action at that owner's expense should they not apply for one. The bylaw sets out 3 exceptions where an owner would not be held fully financially responsible for the replacement cost. If there were roots from a boulevard tree that caused the failure, if the blockage was caused solely by an obstruction in the sewer main, or if the lateral being replaced was less than 35 years old. It is staff's position that none of these exceptions apply for the following reasons. There are no boulevard trees near the lateral whose roots could have damaged the lateral. No other homes along the main reported blockages or failures, and all evidence suggests that the lateral was original to the home and thus more than 35 years old. The evidence suggests that the house service was blocked because the sanitary sewer connection was connected to the storm lateral. Based on our experience, because of this, and because no other properties complained of blockages, staff were confident that the origin of the blockage was not in the main, even though staff was unable to get a camera all the way through the lateral to confirm that. In summary, the steps that Oak Bay has taken with this property were consistent with Oak Bay's bylaws and staff practice. Thank you very much.
Thank you very much, Mr. Rennick. Make sure I follow the process I read aloud at the beginning of this meeting. Council may ask questions for clarification at this time. No comments or debate. Any questions of Mr. Rennick at this point in time? We have your written report as well. Thank you for your time. I would invite, you can go over there, invite Mr. Irwin or his representative. You can come forward. And you may as well, before you provide your presentation, you may also ask questions of the director now or at the end of your presentation.
Thank you. I think I may have a question for the director at the close of my presentation.
Sure.
Press the silver button.
Yeah, just push the button on the piece. There we go. Just state your name, please, for the record, and you're welcome to begin.
Thank you. It's Gordon Brandt, B-R-A-N-D-T. I'm appearing as counsel in this matter for the homeowner, Mr. Irwin.
Welcome, Mr. Brandt.
Thank you, Mr. Mayor and councilors. This appeal or reconsideration relates to the District of Oak Bay's intention to charge Mr. Irwin, a homeowner, for the costs of repairing public infrastructure on public property using public works personnel. If the district allows that charge to proceed, Mr. Irwin will be issued an invoice and will be asked to pay not only for the repair work, but for the associated costs of public works, such as traffic calming. To date, Mr. Irwin has not been issued any invoice or any detailed statement of work, and the amount that's claimed, that's set out in the district summary memorandum of $20,644.76 was only disclosed in that memorandum. This is a large amount for any homeowner and represents a hardship to Mr. Irwin, who is a pensioner, a retired letter carrier, and who already has incurred considerable costs repairing the damage to his basement after the underlying flood event. The bylaw that is relied upon to impose these charges is unusual in British Columbia. In most municipalities, an owner's responsibility ends at their property line. Here, the district claims a right to extend the owner's responsibility across the property line to the lateral connections that extend from the property to the mains. The reason for this appeal, and as Mr. Mayor acknowledged at the outset, it's unusual for an appeal like this to occur, is because the district recognizes and the common law requires that an owner has a right to be heard before the district or a municipal government can impose costs on an individual for work that is performed by the municipality. The municipality owes an elevated duty of procedural fairness to an owner who expresses concern about the process. Before the district can proceed to impose the charge and confirm the recommendation of staff and of the director, the council must be satisfied that the charge is legal and that it is supported by valid authorizing legislation. And while I understand that there have been attempts to limit the scope of this hearing to simply whether the charge is authorized under the bylaw itself, in my submission, council has a responsibility also to ensure that as it makes a decision and approves charges under a bylaw, and as the issue is presented and comes before council, council must be satisfied that the bylaw itself is legal. That's firstly. Secondly, council must be satisfied as well that the charge is reasonable. And reasonable in this context means that the charge is not arbitrary, that it does not unduly interfere with private rights, and that it is a justifiable use of municipal powers. That is also an aspect of council's responsibility when it sits in review of a matter that has come to the council for decision. And thirdly, the process leading to the cost charge must have been fair to Mr. Irwin. And this third matter, which I will speak to all three, but this third matter is a matter that relates directly, I say, to the application of the bylaw in Mr. Irwin's case, and specifically focusing on the question of whether the sewer main exception was adequately investigated before the charge was imposed on Mr. Irwin. So that third matter, I say, is beyond debate. That is something that council can and should consider. And as I will explain, the sequence of events and the information that was provided to Mr. Irwin on this third issue, on the issue of the sewer main exception, proceeded in a way that did not allow Mr. Irwin an adequate opportunity to understand and know his rights with respect to whether that sewer main exception applied. And because the work was done while this appeal was pending, and now we've heard from the director that staff have not been able to determine with certainty where the blockage was, and Mr. Irwin is being told that he refused to conduct an investigation earlier. Well, the events now, in retrospect, prevent us from understanding where that blockage was, and I say that third issue is itself a sufficient ground to allow the appeal and to cancel the intended charge against Mr. Irwin. I will get into the correspondence there as we proceed. I'm going to start by just giving a few facts about the property. I know it's in my submission, and so I don't intend to belabor the facts. I appreciate that the mayor and the council have reviewed the materials that were provided. The property was built in 1960. The existing lateral at issue, the storm lateral, was made of clay pipe, and it had exceeded its expected lifespan. The lateral was 64 years old at the time of the failure, and in its post-lifespan period. It's in my materials. The district has a Phase 1 infrastructure report, and it lists the vitrified clay main, vitrified clay mains. Of course, this is a lateral, but the same material, as having a useful life range of 50 to 100 years. It was at a point in its life cycle where it could be expected to fail. As also in my materials, and I'm sure council, I can take council to the image in the book, but a photograph that was taken on the Irwin side of the property line shows extensive intrusion of organic material blocking the pipe, that it was effectively filled with dirt and with roots, etc. And so the source of the blockage appears to be relatively obvious. I say as well that I understand that the director referred to the suggestion that there had been sewage pumped through the storm lateral. We say there is no evidence of that. There's certainly no evidence that that could have led to the failure of the pipe. The inspection was done post-failure where there had been a backup, and so to the extent that the district relies on matters like, well, it smelled like sewage, I mean, there had been a pipe failure and a backup. Everything is going to become commingled at that stage. And so we say that looking simply at the evidence and looking at the photographs that were taken, it's the suggestion that somehow there was sewage water being pumped through a storm lateral which had failed and was not existent at that point does not explain the blockage and cannot be relied upon as an alternative to investigating the investigation that did not occur, which is whether the sewer main exception applies. So I'll take that. I'll take that. Would it be helpful to go to that photograph, or?
It's up to you. I think we have it in this is the one that's included in your submission, is that correct?
That's correct.
Okay. And that's the vitreous clay picture. Okay.
That's correct.
We have that in front of us, so.
An inspection following the failure showed the intrusion of organic material blocking and damaging the pipe. The plumber advised the Irwins that he understood the property's storm drain had been connected to the sanitary sewer lateral, so the reverse of what the staff suggests had happened. And he further advised that the storm drain itself had been blocked or ripped out after a certain point and did not exist. And based on his assessment, he believed the property was constructed with a single connection into the district's sanitary infrastructure, a configuration that is not uncommon in Oak Bay. And that is, of course, in my submission, and their district staff had and has not responded either way to that information that the Irwins were provided by the plumber who attended on the scene at the time. There's a suggestion that this matter began as a bylaw enforcement matter, that there was a bylaw file that began for work without a permit. And again, I just want to clarify, it's again in my materials, that when this failure occurred, it was an emergent situation. There was flooding in the Irwins' basement, and it was the Irwins who contacted the engineering department to investigate and understand what their rights were and how to get this repaired. And there never has been any attempt by the Irwins to commence construction of any kind to repair the lateral with their own forces. And so I'm not certain if the suggestion was that was attempted, but this is a matter that the Irwins initiated contact early on and quickly with the district in the face of a damaging event at their property. And so we do not accept any suggestion that they did anything other than what they understood to be the right thing to do at the time. And since then, had a series of correspondence with district staff who provided a quote for both lines, then provided a quote for a single line. And at no point in any of this discussion, which is at tabs 6, 7, and 8 of the Book of Documents, was Mr. Irwin told anything about the sewer main exception, nor was he told that he had the right to sign a work order, have a camera put it down the pipe, and determine whether the blockage was his responsibility, or to determine whether the blockage was at the main or at the connection with the main, such that it would become the district's responsibility. That discussion did not occur. Later, as we get into discussion with the district, the first advice that Mr. Irwin has provided as to whether that exception occurred would apply is that it would not apply. And so that's at tab 5. It's the letter dated November 5, 2024, from council for the district to to myself. And at the third page of that letter, it's page number 13. And what we're told here is at the very conclusion, the only circumstance in which the district is liable for the costs of replacing laterals on district property are specified in sections 7 and 8 of the bylaw. District staff advise that none of those circumstances are applicable here. And today we're told, council is told, that district staff were unable to determine with certainty whether the exception in section 8 applies or not, because they were unable to take a camera to the connection between the lateral and the main and see where the source of the blockage was. But of course, Mr. Irwin, who has not been advised of his right to seek a determination of whether these exceptions apply, and is now told, well, they don't apply, is hardly in a position to, of his own initiative, challenge what he's being told at this stage is staff's determination. They've concluded it doesn't apply. Now we're told it may not apply. It may apply, we don't know with certainty. In this correspondence as well, there's a question that is raised as to what is the legal authority for the bylaw. And this is an issue of some significance to the first issue of the three issues that I outlined earlier, which relates to what is the basis for for any municipal government to impose charges on individuals. And this is effectively a charge being imposed on an individual. There is no option for the individual to do the work themselves. A municipality, because it is a creature of statute and a creature of provincial statute, can only exercise, this is a quote from the Supreme Court of Canada decision in Greenbaum, municipalities are entirely the creatures of provincial statutes. Accordingly, they can exercise only those powers which are explicitly conferred upon them by a provincial statute. It follows, and so on. So that's the section that is relevant here. So there must be clear authority for this type of charge to be imposed on a person, and in the community charter brings that down specifically to the level of fees or taxes, and states here that a municipality may not impose fees or taxes, again, very similar language, except as expressly authorized under this or another act. Now, Mr. Irwin is told in this November 5 letter that we're looking at that the district has authority under Section 8.3a of the Community Charter to regulate, prohibit, and impose requirements in relation to municipal services, and that this is a quote requirement. And in subsequent correspondence between myself and counsel for the district, I asked for essentially a better explanation and challenged this assertion on the basis that it does not provide for express language for a charging provision. Imposing a requirement, we say, is not something that can be done as a charge against a homeowner for public works done on public property. And there has been no response to those inquiries. And effectively what we've been told is that if Mr. Irwin wishes to challenge the legality of the bylaw, he must apply for judicial review. And so effectively the response has been that if you want to know why we think it's legal, apply for judicial review. And in my submission, that is not satisfactory, and that should not be satisfactory to council without a better explanation of why a charge can be imposed on an individual under an express statutory provision. The bylaw itself cannot sustain the charges, and so based on the legal explanation that exists to date, I say there is no valid legal basis for the charges whatsoever, and that is itself the first basis, I say, for the bylaw charge not to be imposed against Mr. Irwin. There's no valid legal theory that allows this cost to be provided on him, and certainly none, if there is one, certainly none has been provided to us. And I say as well, it's unfair for a local government to require a member to initiate, a member of the public to initiate a court proceeding to find out what the legal justification is for a charge imposed under a municipal bylaw. That's the first issue, in a nutshell. In regards to the second issue, the reasonableness of the bylaw, I'm going to rely largely on my submissions here, and to summarize them, what I'll say is this: Mr. Irwin does not make decisions about when major infrastructure upgrades occur or do not occur. And Mr. Irwin does not make decisions about how frequently that happens, and does not make decisions about what type of materials are used when those projects occur. And so we're dealing here with a vitrified clay piping that is in the post-lifespan period. It's going to fail. And if it doesn't fail on Mr. Irwin's property, it's going to fail on his neighbor's property or the house 2 doors down. In certain cases, the district has recognized that major infrastructure projects are required and has in those cases, such as in the Estevan area and in there's a second one as well. The Florence area waived those charges where there are major infrastructure projects occurring. And so I say two things. There's an unfairness and an arbitrariness here that because it hasn't come round to the North Henderson area, that Mr. Irwin is on the hook for a $20,000 charge, where his neighbors in a different neighborhood who are having their infrastructure replaced are going to have that same work done at no charge to the individual. When ultimately the issue here is, unfortunately, aging infrastructure. Yesterday, I'm sure Mayor and Council are all aware, there was a sewage break, and it's created a bit of disruption in Oak Bay. And the quote from the Czech TV news story from the district representative is as follows: "It's just a random thing," Brozak told Czech News. "The main had a heavy break and we're responding to it. He said the damaged section is part of Oak Bay's aging infrastructure, a mid-1960s asbestos concrete pipe nearing the end of its lifespan. It's one of our older pipes," said Mr. Brozak. "The infrastructure is getting older and we're working at replacing it as much as we can." And that's the scenario that Mr. Irwin finds himself in, aging infrastructure, and he happens to be at the point of the break. And so we say, in addition to what's set out in more detail in the submission, it's unfair, it's arbitrary to penalize the person or to have that person bear the responsibility who sits at the point of failure where the issue is systemic. I'm going to turn to my third argument, barring any questions on that, which is the issue of procedural fairness and the sewer main exception.
Do you need a glass of water?
Oh, sure, thank you.
Thank you. It's thirsty work talking into a microphone now.
So I'm looking at the district's summary memorandum here onto the third page, where the memorandum goes through the different exceptions, the boulevard exception and the sewer main exception. And under the sewer main exception, the district says as follows: "This section does not apply because it requires the owner to commit to paying the cost of investigation." Well, that's a different explanation than what Mr. Irwin was offered on November the 5th, which was staff have advised that it does not apply. Secondly, the owner refused to pay any cost associated with this work. That's also incorrect. The work here must refer to the work associated with investigating the blockage. That's something that had never been put to Mr. Irwin. In addition, Mr. Irwin has not refused to do anything. In the November 5 letter, Mr. Irwin is told, "You have a right to appeal the decision to council." And in the following, and again, and just to read what this says, the district will provide your clients with an opportunity to appeal a decision to impose the connection or repair cost to council. In the email correspondence at tabs, I believe it's tabs 8, 9, and 10, mainly at tab 9, we follow up with council, council for the district. November 19th, could you please provide further detail regarding the process for appealing to council? November 22nd, your letter does not indicate the statutory basis for the appeal, nor have I been able to locate any publicly available information regarding appeals to council. Given the timelines in this matter, I would appreciate hearing from you at your earliest convenience. November 22nd, again, a council for the district responds, I'm waiting to receive information from the district, at which point I will respond, likely next week. We follow up again on December 3rd, right to follow up regarding the appeal process. And then eventually on December the 11th, we're advised to give a written notice to the corporate director, and that's done 2 weeks later on December the 24th. So there's no delay here on the part of Mr. Irwin in seeking to exercise his appeal rights. He's told he's had a right to appeal, and he follows up a number of times asking how he can go about exercising that right. But is told in the district submission here that he's refused. Well, an appeal process that leads to a deemed refusal is not really an appeal process at all, unless a member is given notice that the work is going to occur and that you're going to lose your rights under the bylaw to claim certain exemptions or to have certain work done. And then that did not occur in this case here. There is additional correspondence on this issue. Again, under tab 9 and moving forward in time at page 32, I have a question to council for the district about preserving the evidence here. And council for the district advises, hi Gordon, the district says it will take pictures, but that it won't be possible to remove the pipe without breaking it up, so no real possibility to preserve it. But in my view, this does not really affect anything, as the circumstances under which the district could potentially be responsible for the cost of a new lateral are not present here. And so again, Mr. Irwin is told on January the 21st that effectively none of the exceptions apply. Now, he does receive updated information in that regard on January the 24th. That's at page 29 of the submission. And counsel for the district advises as follows. Hi, Gordon, I have spoken with district staff, and they will take pictures of the pipe at the time of removal. When they replace the lateral, they will also be cutting out a piece of the main and replacing it with plastic pipe, because the new lateral will also be plastic, and they cannot connect a plastic with the existing main. When doing so, they will take pictures of the connection and be able to see if the issue is caused by a blockage in the main. A blockage in the main is the only other reason under the bylaw that the district would be required to pay the cost of replacing a lateral, other than the pipe being less than 30 years old or the issue being caused by a boulevard tree, both of which I addressed in my previous email. So now on January the 24th, the district is advising Mr. Irwin through counsel that they're going to investigate when they do the work. And so, of course, he's not going to be seeking at that point an independent investigation under section 8.1 of the bylaw to see whether that exception will apply, because he's been advised by the district, we're going to look and we're going to see whether this exception applies. But again, in staff's report, we're told the sewer main exception does not apply because it requires the owner to commit to paying the cost of investigation. The owner refused to pay any costs associated with this work. And that is where the unfairness arises in this case in imposing the cost on Mr. Irwin, because he's told a number of different things about this exception, that it wouldn't apply twice, and that the district will look into it. He's in good faith carrying out this appeal. In the meantime, the work is done with the assurance that that will be investigated, and now is told in staff's report that the exception does not apply because he has in some way refused, and staff acknowledge that they cannot determine where the blockage was with certainty. There is, and the director referred to what I would say is speculation or at best circumstantial observations about where the blockage may have occurred and why. But the suggestion again that sanitary water was being pumped through a storm drain is not supported by the other evidence, including what the Irwins were advised by their plumber as to the state of the storm drain, which could not have sustained sewage water and it possibly never existed in a complete connection to the main. And again, this has been in our response since the materials were provided to council, and if the district had a response to that, we ought to have heard it, and we didn't. And so the best I say council can conclude is that there is no reliable information on which to base a decision as to where the blockage occurred. And the work having been done while Mr. Irwin his appeal is under process, while he was told first that the exception wouldn't apply and later that the investigation will be done, and now we don't know the answer, he's been deprived of the right to seek a determination of whether the sewer main exception applies. And that is a breach of his rights of procedural fairness. And in the circumstances, the remedy here is for council to decline to impose the charges on him and allow Mr. Irwin's appeal. So that's the only way that he can be assured of a fair outcome here. I noted that I do have some concern about the nature of the speculation. I don't need to say more about that. For the balance of the items, I'm going to be relying on my written submissions, and so subject to any questions from council, those are my submissions this evening.
Thank you very much. You indicated you may have a question for staff, and I'll give the staff opportunity to ask clarifying questions of you as well, but please go ahead.
I think I've covered the issue. I think it was mainly something arose in our discussion.
Okay, thank you very much.
Thank you, Mr. Mayor.
Oh, you can say, you may as well stay seated there, because we may have some questions back and forth. To Mr. Rennick or Mr. Bordelin, are there any questions that you may have for the applicant?
No, Mr. Mayor.
Okay, thank you. So we have the opportunity, if there's any clarifying questions from members of council. I believe that's, I want to make sure I get procedurally here correctly. I think this is, so we haven't had one of these in my time on council, so we're just making sure we follow the appropriate process here. We are entitled to questions of staff or the applicant, is that correct? Clarifying questions, okay. I'll turn to council if there are any questions. Go ahead, Councillor Braithwaite.
Thank you so much, Mayor, and through you to our staff. There was a comment that was made in regards to traffic calming, and that's a cost that's added on to this process of replacing the pipes.
Traffic control, I think it was.
Or sorry, traffic controlling, yes. Is that true that we actually add the charge of traffic controlling onto that cost?
Mr. Rennick?
Through the mayor, Schedule A of the Public Sewer Bylaw, in listing out the connection fees, states costs for traffic control, hydrovac, an engineering consultant, and additional concrete will be assessed with each sewer connection. These costs will be collected in addition to the bylaw fee. On completion of the work, any unused contingency fees collected will be refunded.
Thank you.
Thank you. And does that tend to be a large amount, or in this case, or do we know what that amount was in this case?
Through the mayor, I don't have the specific amount for this one just because I don't have the itemized cost breakdown in front of me, but on a road like Henderson that is a bus route, that is a major route, I would say that yes, the traffic control costs here would be extensive.
Thank you. And just one other question. When was the first contact between Mr. Irwin and staff?
Mr. Rennick?
Through the mayor, based on the documents that were provided by Mr. Irwin, that looks like that was in January of 2024.
Okay, nods of support from the, yeah, Mr. Brandt. Okay, thank you. Are there other questions from members of council? Councillor Smart?
Yeah, thank you. Through you, Mayor to staff. With the mention of an offer to take a photo of where the connection was to the main during the point where the main was going to be cut for the new plastic piece for the plastic to plastic connection, was a photo ever taken, and if not, why? Thank you.
Mr. Rennick?
Through the mayor, I do not believe that a photo was taken, and unfortunately, I'm not able to comment on the why.
Councillor Appleton?
Thank you, Your Worship. So I think this is probably for Mr. Brandt. With respect to the photo that is included in the correspondence of September the 19th, purporting to show a blockage, is the section of pipe shown in this photo the lateral or the main?
Thank you, Councillor Appleton. That is, as I understand it, a photograph of where the lateral connected to the Irwin's property. So it's on the Irwin side of the property line where the lateral would connect to. It's certainly not the main.
Go ahead.
Thank you. With respect to maintenance, was routine maintenance conducted on any of the laterals by the landowner?
Mr. Brandt?
I don't have the answer to that question.
Go ahead.
Thank you, Your Worship. Just for clarification, so I'm hearing two different things. I'm seeing in the memo that there was an offer put to Mr. Irwin to photograph or otherwise investigate with respect to the sewer blockage. The memo indicates that that was refused. Mr. Brandt is saying that that is not the case. Can we clarify that there was an offer put to Mr. Irwin to pay for such an inspection that was specifically declined?
Mr. Brandt, I might turn that to you, to your knowledge.
So, Councillor Appleton, the discussion of the photograph being done was at the stage where the district had already made a decision to proceed with the work. And so the discussion at that stage was that as they proceeded with the work, they would photograph the main and the connection point between the main and the lateral, and we would be able to ascertain as a result whether the sewer main exception applied. The issue of refusal, my understanding from the district's memo is that it doesn't relate to that as having been, because there was no monetary request made at that time in January when the work was immediately pending. I think it refers more generally to the appeal that Mr. Irwin had initiated around the charges being imposed at all.
Councillor Appleton?
Thank you, Your Worship. So I made follow up on that because I'm referring to the information in the staff memo. This is on page 3, speaking to the 3 circumstances in which the district can be responsible. Under the sewer main exception, it states specifically that the section does not apply because it requires the owner to commit to paying the costs of the investigation. The owner refused to pay any costs associated with this work. So I'm looking to confirm. I'm hearing two different things. I'm looking to confirm that that was something that was executed, that conversation happened or that communication was relayed.
I'll probably turn to staff on that one.
Through the mayor, the bylaw states at the start of section 8 that where the owner of a property served by a public sewer commits to the payment of the associated costs through the signing of a work order, the engineer may cause the investigation of a sewer connection with a view to assessing its condition. If such investigation reveals that the source of the problem which triggered the request for investigation lies not with any portion of the sewer lateral, but with the sewer main or the point of connection to the lateral thereto, then the engineer shall release the owner from the obligation created by the work order. So staff's view is that because there was no signing of a work order or committing to the payment of costs, that's why we're saying in the memorandum that that section doesn't apply.
Are there any other questions for the applicant or staff? Just for my clarification, looking at the pictures here, it doesn't seem like there's any dispute that the lateral or laterals, probably, since they were both ultimately replaced, needed replacement. Is that a fair understanding?
So my understanding, Mr. Mayor, is that a new storm lateral was installed. I don't believe, and I can just confirm, but I don't believe the sanitary lateral was replaced.
Maybe ask that.
I believe, because if you look at,
I can turn to the staff if you wish. My understanding was that they ultimately did replace both laterals, but Mr. Rennick?
Just to clarify, there was only one lateral there, but Public Works did install 2 laterals.
Okay.
So it wouldn't quite be accurate to say that 2 laterals were replaced. There was no evidence found of a second lateral.
Okay.
and that's there was no evidence found of a storm lateral, correct?
Mr. Rennick?
Yes, that's correct. And I just want to point out that a lot of this is theoretical until you open the ground, and that was what was relayed back to Mr. Brandt, was that digging with a backhoe, old broken pipe, we might not be able to take it out in exactly the condition that it looked like before the ground was opened.
And without evidence of a storm lateral, there couldn't have been sanitary water pumped through a storm lateral.
Okay, thank you. Yeah, okay, I'll leave that there. Oh, sorry. Is there an additional comment that wanted to be made or no? Okay. Just, Mr. Rennick, we had a little back and forth here in terms of not having pictures taken. Has there been any conversation from the staff, any indication of what was found when that section of main was replaced at the time of connection? Was there any blockages of the main at the time?
No, there were not. And I would just point out that the lateral coming from the house is 100 millimeter diameter or 4 inches, and the main is 250 millimeter diameter or 10 inches. There was no evidence of significant blockage found in that main. The house is in the middle of the block. There were no concerns raised from either of the neighbors, no cause for suspecting that there was a blockage in the main.
Okay, thank you. And then just in terms of the invoice that's being considered here, I just basically want to make sure I understand what was or was not included in that. And my 2 primary concerns was the replacement of the main itself included in that cost, like that section of main, in that total cost, or is that borne by the municipality? And were there any late fees? I appreciate this is taking a bit of time to go through an appeal process. Does that fee include late fees, or is that entirely the direct cost of the work being done?
Thank you, Mr. Mayor. The section of main that you're referring to, where we have to cut out a section of main in order to couple in the new pipe, that is included. Also included is the traffic control. There are no penalties, interest charges, anything like that. This is the direct cost of the work to the municipality.
If I may just add for completeness, Mr. Mayor, that other than the dollar amount that's provided in the district summary memorandum, we have not been provided a copy of that invoice, so I'm unable to comment on it.
Yeah, I appreciate that. Thank you. Any other questions from members of council to either the applicant or to staff? So I guess I may put it to council. Does council wish to have consultation with our legal advisor, who is here in the room as well? In which case we can just close the meeting and step into the next door meeting room and have that conversation with Mr. Bordelon. So if that is a will of council, we can certainly do that, or if not, we can certainly stay here and do the deliberations. I note that our notes on this is whether the deliberations take place with the parties present or not, but we are anticipated to make a decision tonight, I understand. Is that correct? Yes, if possible.
For clarity, Mr. Mayor, you don't have to make a decision tonight.
Okay. Thank you. Go ahead, Councilor Braithwaite.
Just one question in that Would a discussion around the actual charge, the amount of the charge, would that be best to be had in a closed room with our staff?
I had heard from Mr. Rennick that there was no, I don't think that's a closed meeting matter. It would just be that the detailed invoice is not here tonight for that. And maybe for our clarification, those charges that are on there are complete within the bylaw. They're not sort of separated. That's the list of services that are included within the bylaw. Is that correct, Mr. Rennick?
Through the mayor, we haven't provided backup. We typically don't on these. However, because all of these costs are staff time or equipment time from change orders or, from time cards, or their materials from vendors, we can certainly surface all of those costs if that's something that council needs to make their decision.
Thank you. I'm not sure if it is. It's up to council whether they want to see that, but I might suggest we probably, should this occur again, I think it's probably worthwhile having, so there's no sort of questions in the room here. Whether it's germane to the discussion here tonight, I don't know, because I think that would be philosophically whether or not we're going to consider partial costs, because really what was in front of us is the fairness of the charges as a whole, not necessarily the individual charges within the bylaw. I don't see any other questions, so you're welcome to stay here in case there is a question that comes up, but at this point I think it's really over to this table to give some direction. Note that the motion here is to either uphold the fees that are being put forward here, the decision made by staff under the bylaw to require the owner to pay, or we can set aside the decision in this case. I think, I don't think that there's so if someone wishes to make a motion, I'm happy to take debate on that motion.
I'll make a motion just for the ability to have a debate on this. So I will move that council upholds the decision to require the owner of the property located at 3383 Henderson Road to pay the cost of installation under Section 2.4 of the Public Sewer Bylaw 1996.
It's moved and seconded. Appreciate the formalness of reading it out. I think it's appropriate for the hearing.
Thank you, Mayor. And I find this a very difficult one to grapple with. I know that based on historic information that we have, that this is a normal thing that would happen within our municipality, that a resident would have to pay for something like this. In the 17 years that I've sat around this table, I have not ever come across this before, so this is the first time in my memory that this has been brought to us. So I'm finding it difficult to determine exactly what to do, so I'm going to be very interested to hear what my fellow councillors have to say about this. But my inclination is to go with the staff recommendation, but I'm happy to hear what everyone else says.
Other speakers? Go to the seconder, maybe, as put you on the spot.
Thank you, Your Worship. Yeah, similarly, I think it's a challenging one to wrestle with. I think what the matter, as has been put to us in front of council, is whether or not council has the ability to establish and enforce a bylaw of this nature, and I believe that we do. We have heard many times from the community and understand very clearly as a council that the cost burden on the landowner with respect to laterals differs from community to community, and I think council is well aware of that in terms of its application. It is nevertheless not unique to Oak Bay, and it has been in place for quite some time and is well understood to be the case in the community and has not been challenged thus far. The speculative condition of the main with respect to the cause of the blockage. What I've heard from staff and what is prospected here is that there was no evidence that was the case, and the general condition of the district's infrastructure, I feel, is not an appropriate basis to conjecture about whether or not this specific piece of infrastructure was at its full capacity or damaged or non-functional in any case. So I think in that case I have to return back to the fundamentals of the application of the bylaw, which is whether or not the district has the ability to apply this bylaw scheme. I believe that they do. And that the costs associated, we can talk about the costs, but the costs, as the mayor has referenced, are integrated into the bylaw. So the matter is whether or not the bylaw is appropriate, not whether or not the costs in the bylaw are costs affected by the execution of the bylaw are appropriate. Thank you, Your Worship.
Thank you. Is there anybody else who wishes to speak to the motion? Go ahead, Councillor Patterson.
Yes, Mayor, thank you. I too believe that the municipality has the ability to apply the bylaw as it is set forth. And while it may not be typical to some districts, it is not unheard of in other districts. And so I think it is fair and reasonable that we have continued to follow this path. I think that because of the differences in size of the pipe, if there had been blockage in the main pipe, albeit that there was no formal inspection carried on, it would have evidenced itself quite readily if the blockage was in the main. And obviously, there is blockage in the lateral. I think it is also incumbent upon homeowners to ensure that they have sanitary and storm sewers on their property, and that they are functioning accordingly, so that they actually don't cause problems within the public services themselves. So I think that yes, I support the recommendation made by staff in that we have the ability to apply the bylaw, and I think that the staff did act in the best interest of providing repairs to the service as promptly as possible to put the homeowner in a condition to mitigate any further damages to the property. So I think that it was fairly applied, and the staff acted appropriately in the circumstances.
Anybody else wish to speak? If not, I will, I'm happy to call the question. But I think just as a spokesperson for council, I probably just feel like I owe you an explanation as well. And I really do appreciate the thoughtful layout of the request. And so I'll just very briefly respond in those three areas. So the first question is whether the bylaw is legal. I do believe it is, and I will just say I think there is no right way of doing this. It's been a topic of conversation, but not sort of formal debate about potential change of the way that we apply it. And I will just share that there are negatives, and that there can be very significant unforeseen costs to homeowners if something goes wrong, particularly if you have a house located a long way away or over rocky terrain and so forth to these connections. The rationale for it that I've heard that I think has some merit is that variation in cost is on the homeowner itself. It provides benefit to the homeowner, and so for the municipality to absorb exceptional costs and exceptional properties to the general taxpayer probably isn't the right, or it certainly can be argued wouldn't be the right path. And the second reason, rationale I've heard for it is that there is a mechanism there, an incentive for homeowners to inspect these laterals all the way down to the connection point. Because there is multiple ways that those things can fail, and separating those out, it's very difficult for a municipality to turn laterally and look up the laterals to the property line, where it's reasonably straightforward if a homeowner's doing their regular inspections, and we encourage them to do so, to continue that path. So I do believe it's legal. I think the is it reasonable is a harder one. It's really at the judgment of this panel. I do appreciate the back and forth that happened with staff and the applicant on this one. I know there was obviously some miscommunications back and forth on that a little bit, but I saw nothing there on either party that was malfeasant or anything else. It was obviously people trying to find a solution within the bounds of what was possible. And then the last question was the sewer main adequately investigated? And this really boils down to, can we make an exception on the sewer main exemption? And I would think in this case, if there was a notable blockage of that main, then we would, that would have been apparent when it was taken apart. I don't, so I to my mind, in that procedural fairness, I appreciate that the language back and forth as to why things were asked for. There was no charge for the inspection, but there was also a piece of there. So I'm comfortable with the motion that's on the floor. I do appreciate the difficulty this poses to the owner, and certainly if there's anything we can do to help in that front, in terms of spreading out payments or other things, then we can consider that. But in terms of the matter of tonight, which is the, should this be upheld, I do support the motion on the floor. Councillor Green, you wish to speak?
Yes, thank you. I just, I want to say I will support the motion on the floor, but I also want to say that I don't think the community is well informed in this regard. When we moved to Oak Bay in 2010, we had no idea that we were responsible for maintaining the lateral to the street. So I think I would encourage us to think about a good communication strategy and remind homeowners that this is important, because I think they are not well informed about that responsibility. In my experience, I've had a number of people completely surprised by having that responsibility. So I would encourage us to think about engaging and communicating more pointedly with our community on this issue. Thank you.
Thank you, Councillor. I know I was surprised. It happened before I was on council. I'm going to call the question at this point. All those in favor? Any opposed? I want to thank the applicant for coming. I thought, I appreciate the thoughtfulness and the arguments made here tonight. And as we go forward, this will, if this matter comes forward for discussion, it will certainly inform some of the conversation about how we manage this in the future. So thank you.
Thank you, Mr. Mayor, councillors.
Thank you. With that, I need a motion to adjourn the 6 o'clock meeting. Moved in second. All those in favor? Any opposed? Not opposed?